Hi, and welcome back to Ladies in Law. I'm Michaela.
And I'm Allison.
And last week we talked a little bit about building a relationship with your client, building rapport, creating a safe space. And so this week we are going to kind of, build on that and talk about the next step, kind of work through the timeline of a lawsuit from inception of it filing to kind of what the next step is and all of the steps in between. So today let's talk a little bit about discovery.
Ew.
So, Allison, in preparing for discovery, how do you like to kind of set it up? Do you like to start talking to your client about what they might expect in discovery way before you're served discovery? Does it kind of happen once the other side serves you discovery?
Oh my gosh. Okay, so let's back up. So most people don't know what discovery is. So discovery is the written exchange of questions between both sides. And so that's my very first step. I call the client and I'm like, look, actually, not even during discovery. Let's say we just signed up a case. I kind of explain, look, your case has different phases. So right now, we start off in the pre-litigation phase, the phase before the lawsuit. Once we've gotten to the phase of the lawsuit, that's when I call them and I'm like, all right, look, we filed a lawsuit. Now the next step is discovery. What is discovery? Discovery can include various things. It's written questions that both sides exchange about the facts of your case, your injuries, your treatment, and potential future treatment, things like that. Then there is your deposition. And so that's a whole other conversation, but I'm like, these are just the overviews. And then discovery also can include the defense medical exam, where the defense has a doctor evaluate to talk to you or to provide opinions as to whether your injuries were caused from this incident. And then there's all these other things that happen during discovery, but that's like my initial talk. So I'm like, all right, so this is discovery. And the reason it's important, it's because it facilitates an exchange of information. So we don't have anything to hide. Mm-hmm. So we want to provide as much information as we can to the defense so that they can see your case, evaluate your claims, and then really go back and forth and see if maybe there's a potential way for us to resolve the case short of going to trial. Do you kind of do something similar where you're explaining discovery to the client?
Totally. Yeah. I think I always want to operate on this baseline of like, this is their introduction into the law. Mm-hmm. This is their introduction into the legal field. I went to school for this. They most likely didn't. So
they don't even teach this in law school.
No, I know they really don't. No. I was just going to say, but even then you're not really. But we have a little bit more knowledge than the layperson. So I like to first be like, hey, are you at all familiar with the discovery process? And kind of based off of their answer, sometimes they'll have an idea where it's like, oh, there are questions that I have to answer. And it's like, yes. Mm-hmm. And then I'll build off of that and say exactly what you did, where it's like, this is what to expect. Mm-hmm. This is our philosophy with it. We have nothing to hide. And so if you are giving me all of the information, then like, I'm gonna put that into this discovery. You're going to have an opportunity to look over it so that you can affirm that like all of this information is correct, or maybe I missed something, or maybe you didn't think of something at the time, but now you have it and this has jogged your memory. So kind of taking the client through the steps, what to expect. Yeah. So setting like those expectations too.
It's funny. So before the initial disclosures, which for anyone that wants more information about that, we also did a webinar on that. But before initial disclosures became a thing, I typically had the discovery talk a little bit later in the case. Now I'm doing it as soon as I get assigned a file. It's like, okay, I need you to understand like the phases of litigation, and one of those phases is discovery. Mm-hmm. And the reason it's becoming so important is because a lot of these conversations have to happen a little bit sooner now.
Totally.
In the event that another party to the case demands the initial disclosures. And so it's a little overwhelming. I will say, like, most clients, when I first explain discovery, they're like, oh my gosh, like this is so much. So I kind of break it up. Like the first time I bring it up, I make it, this is just like a written exchange. Just think of it as like a written exchange of information. And then once we actually have that first discovery meeting, it's like, okay, this is what it looks like. These are the questions that the other side has sent us. And I literally have it on my screen, or I have it next to them. And I'm like, I need you to be familiar with this document, because sometimes in depositions, the defense will say, have you ever seen this document? And they're like, no. Like, no, yes, you have.
We went over this extensively.
Yeah. So I have them look at the questions these are all the questions defense has sent us. Sometimes it's hundreds of questions. Mm-hmm. And so you cannot do that in one meeting. Mm-hmm. You and I have talked about it. We typically like to have multiple meetings because the memory is very fallible and the memory does not always work as we want it to. So multiple meetings to go over discovery and then have the client have ownership. They need to understand they're signing under penalty of perjury. It's not something they can just brush off and like, oh yeah, I saw a doctor back in 10 years ago. It's like, no, like we need to break this out and flush it out and really like be very intentional with how you're answering. So
totally. So do you think in terms of preparing discovery responses, do you kind of preempt what the other side is going to ask you? And do you have conversations with your client prior to even being served discovery, kind of going over a lot of information that you know is going to be eventually asked? Or do you kind of wait to go over those conversations with your client until you have it in hand?
Oh no, I have those I go through the basics. So for anyone that's not familiar, there are these, it's a form that's approved by the Judicial Council, I believe.
Exactly.
But it's called form interrogatories. And those are served on every single case. And so immediately, as soon as we have a new client, I kind of go through like a cursory review of those. I don't go super in depth. Like I don't need to know where you went to high school, but I definitely go through your past medical history so that I can order the records immediately.
Yes.
And then I won't ask them, for example, I don't go through and sit down with them and ask them question by question. I just make it more of a conversation the first time, get the records as soon as I can. And then once we get closer to the actual discovery call, that's where we're going question by question. But I think they need to like be familiar with it early on in the case because I think part of being an effective litigator is making your client understand I expect a lot from you. Mm-hmm. I'm going to put in 100% effort, but I also need you to be responsive. And these are my expectations of you as a client.
Yeah. I think that's such an important conversation to have because it's like, I can only show up at 100 if you're also matching that energy.
Yeah.
And like, I can only advocate for you based off of the energy that you're putting into this too.
Yeah.
Because like I have a baseline and I'm going to advocate for you regardless, but it's going to make my job a lot easier.
Yeah.
And me able to advocate for you in a way better way if like you're matching that energy.
And also I think as part of our job is to work with the opposing counsel, it's embarrassing to ask for multiple extensions to discover one or two, typical, customary.
Yeah.
Once you start asking for like months and months of extensions, it's embarrassing. Your reputation is also being assessed by the defense attorney. And so I try to have as much information as I can early in the case. And then those meetings with a client, those follow-up meetings for maybe very specific questions that are sent out. And we can get into a couple of examples. But for the very specific questions that are asked, we need more meetings. And so I definitely try to make sure I have a good rapport with defense counsel. And if I'm asking for extensions, I ask for reasonable extensions. I try not to prolong it, but it becomes difficult if you have a client that, maybe they don't trust you. Maybe they're not answering the phone. You're trying to get these verified and they're just not being responsive and doing their due diligence. And one of the things I did want to clarify, so for these responses, it's under penalty of perjury. And so you have to have your client sign saying that everything that they've written is to the best of their knowledge and recollection. So I definitely try to make sure they understand the weight of the responses.
Absolutely. Sure. And I think so. You've kind of touched on this a little bit when it comes to what kind of questions from the form interrogatories are you asking them before you even get that in hand. And I think one of the most important ones to really talk to them about are their medical records and their medical history, because in being their advocate and wanting to be proactive and not reactive, we want to get our hands on as much information on their history as possible. And so if you're only now at the time that you're getting discovery where you have to respond within 30 days if you're not asking for an extension, that might not be enough time to order records. So if you're not having this conversation with them prior to that actually being served on you, then you might not have had an opportunity to look through these records before handing them over. And you always want to be able to kind of like preempt it, because you don't want some responses to be like, never had any back pain. And then all of a sudden it's like you get the records back and it's like, oh no, like they forgot about that one time when they were this age. And which like, because of course, like
Yeah.
Again, fickle memories.
Yes.
It's a thing. And especially if you only had one conversation with them, maybe it just, really seriously slipped their mind. So I think you touched on the importance of being able to have those like, hey, what is your medical history? What kind of doctors did you used to see? Did you ever have pain to this area of your body? And realistically, hopefully you're having that kind of more in the intake time period. But again, like it might come up later.
So obviously in a deposition, your client has a right to privacy. And so the defense attorney can't ask them about prior medical history that has nothing to do with their claimed injuries, right?
Super important distinction.
However, I still ask.
Yeah.
So sometimes, especially with something as, for example, like a back issue, sometimes the way that medical records are written, it's a little vague. At least for when you're reading through them initially, right? And so sometimes I'll ask a client like, look, have you had any surgeries? Have you had any visits to the ER for an unrelated issue that potentially could be misconstrued? For example, let's say your client has a back injury and they had an unrelated hernia surgery, but in the record, it says complaints of lower quadrant pain or something that's vague like that.
Yeah.
We know because we have the records, it's unrelated.
Yeah.
But if you're not having those conversations and trying to jog their memory about any prior surgeries, for example, even if it's unrelated, you can trust us. We're your attorneys. It's 100% confidential. I need to know about it so that later on, if it's asked in your deposition, I can object properly and say it invades your right to privacy. And then just tailor it, because sometimes things can be a little blurry and at initial glance, if I'm a defense attorney and I'm going through your medical records and I see that there was a complaint of pain, I'm like, oh, that's a prior injury. And maybe it's not. Maybe it's completely unrelated, but you need to know 100%.
Totally. And so just kind of in terms of like applicability, how do you, when you've gone through this deep dive of medical records, how do you as their attorney kind of file that? Do you take notes and you're like, oh, on this page of this medical document, remember that there's this? Do you highlight the document itself and have one saved to your file? Like, what is your kind of process with that?
So coming from the defense, we always did our own medical summaries. And so it's a skill that I learned there that I still carry over to plaintiff's side. I do my own medical summaries, and it's time consuming and it takes a lot of effort, but for me, I know that there's companies that do it for us and that there's great software now that you can do within 24 hours. You dump all the medical records. For me, I need to know everything that's in that file. And so I do my own medical record summary and I highlight like, okay, on this page, there's this reference. And I just do a chart. So I have pre-incident, post-incident, and then I have the dates, the medical treatment, and I just do my own little abbreviations. Genius. But I have to do it. It's just like my OCD that I'm like, I need to know everything in this file.
Yeah, and I bet that that's so incredibly helpful when it gets to the point of doing like expert depositions or things where you already have this intimate relationship with their medical records.
It does, especially because later on, it's always kind of, you do it the initial round and then more records come in. So I constantly have to update it. But by the time, hopefully everything's been updated consistently, but by the time of trial, I have this clean record of everything and it's fresh in my mind. Yeah. And so when I'm doing a doctor deposition or an expert deposition, I just go to my medical summary and I'm like, okay, here it is. And we would actually call them medical chronologies because it's more of a chron, but for me, that's what I do. And it's been super helpful for me.
I'm like literally like filing that away. I'm like, I need to start doing that.
But it's not, so I would say it's not realistic on every case.
Right.
I think your bandwidth sometimes will allow you to do that, but there's obviously been times where I'm swamped and I'm like, oh shoot, I need to get to that MedCron.
Yeah.
It helps if you do have a company that can help do those for you. I know there's so many different companies that do it now, but maybe it's a little bit more efficient to hire a company to do that for you, especially if you're a solo practitioner and you don't have the time to sit there and go through and do everything. But to the extent I can, that's like my goal. I'm like, okay, I'm going to go through all these medical records, but I also do it as part of my, my Howell chart let me explain that.
Yeah.
So part of discovery is breaking out every medical provider that you've seen and then the amount that was, applicable that you're claiming in your case. And that number is the Howell number. And so I go through, and as I'm building that chart, which is a response to form interrogatory 6.4, I have my MedCron ready, which was a summary of all the records. I have my Howell chart ready. I have my discovery, like my form log. So I have all three, and I'm working on them at the same time. And it's a little time consuming, but it helps me understand my case.
Yes, and a lot of the time, all of the information that's needed for each one is going to kind of be found within the same document. So that makes sense to my brain, where it's like it makes sense to be kind of working on them simultaneously, as opposed to being in a record and doing one and then going back to that record to do the second, you know?
Yeah.
So I think that's genius. And I think even if you don't have time to sit down and kind of like start that from scratch, even having another service that has made this chronology for you, you can kind of break it up and make it more digestible for you, kind of like a little cheat sheet, you know, where it's like, oh, now I'm going to put some of this information into a little chart.
I think it's huge if you have access to law clerks, have them do your medical chronologies for you, because so one thing I was doing when I clerked, I would do the MedCrons, and I would say, look, I reviewed 3,000 Kaiser docs. Out of all of those 3,000, the only relevant pages were like, you know, X to X. And so it helps the attorney that's probably swamped focus in, okay, I'm going to review those very clearly. The other ones I might just skim through because they're not, you know, it's like other unrelated issues, like came in for a cold or whatever, but it still helps save time. So I think if you have a law clerk that can do that, that's amazing. Using AI, there's so many services now. And then obviously there's different companies that have doctors that can review those as well. But something to help have it all organized beautifully, because going through thousands of records, it's a lot.
It is a lot. But so necessary to have that kind of like intimate relationship with their records to truly see the full picture.
Yes. Aside from, so 6.4 is critical. And then another one that I really spend a lot of time on is the 12 series. So
yes. Sorry. So 6.4 is asking for every single medical facility that client has been to from the date of the incident to the present. So whoever they've been treating with, you put their name and address of the facility, the dates treated there, the type of treatment, and price to date. So like the billing to date is what that one is. And then 12 series, take it away.
12 series. There's a lot. That one is very specific. So I recommend going through, and there's like an A, B, C, and D. Go through each one. Don't just group them all together. I know some people do that, and maybe it's a stylistic preference. I go through and identify each individually. So the 12 series is just, in general, it's witnesses. So the first, I believe, asks witnesses that actually saw the incident. So let's take a car crash, for example. Maybe there was a witness that was just in another vehicle and witnessed the entire thing. Immediately need to list that person. Maybe it's the officer that witnessed the skid marks and the debris and everything. Another witness. The officer that wrote the report, that's a witness. And then the last one is the most critical, for me at least. It's the subpart D. It talks about witnesses to your client's pain and suffering. And you have access to your client way early on, so you need to have these conversations early on. Some people will list, they'll just write like a blanket statement, plaintiffs, friends, family, and coworkers, something like that. I try to be a little bit more specific. If I don't really know who in the client's life is going to be a good witness, maybe I'll just put like coworkers. But for the most part, I always list a spouse. And then anybody that was intimately involved with like the client's surgery, maybe their child, they have an adult child that took care of them. I list that person. And then if there was like a very specific doctor that maybe saw the client right before she had her collision, I actually list them right away. Yeah. So that later on when you're prepping for trial, they can't say, oh, you never listed this person and you're surprising us on your witness list. It's like, no, they were listed on our discovery responses at the inception of this case. So if you didn't take their deposition, that's on you. But are you as specific with your 12 series?
Yeah, absolutely.
Yeah, I think
I want to just constantly be giving them as much information as they possibly can have. And by they, I mean the opposing side.
Yeah.
I want them to have all the information. Like, I have nothing to hide. This is everything that bolsters our case. These are all of like the facts supporting all of the claims that we're making, like here, like, you know, if you need to ask questions of this person, ask questions of this person, because like, I want you to have the full picture. And
I think just a practice tip for any newer attorneys. So you file, you do your responses and you serve them early on in your case. You might learn a lot as the case progresses. When it gets, I would say like 120 days prior to trial, look at your responses and supplement that 12 series. Maybe now you know a very specific coworker that like helped your client at work and, you know, went to the bathroom with her, things like that that come up later on throughout the case. Those people need to be listed in the 12 series. And they're called your plaintiff's responses to supplemental interrogatories. So if you're served with supplemental interrogatories, which are basically when the defense is saying, go through all of your prior discovery responses and update them, I will always update my 12 series now. And then if you're not served with supplemental interrogatories from defense, you can just serve amended discovery responses and list those individuals that you potentially might call at trial, because you just don't want to be in a situation where you list someone on your witness list for trial and defense is like, I have never seen this person.
They have not had any notice.
Yeah. So just good practice tips for sure.
Totally. And I think that touched upon what my next question was going to be, which is like, if you find out new information, and that you didn't have at the time that the discovery responses were sent, is it your practice to acclimate?
Acclimate. I like to acclimate.
Do you like to acclimate? To update them on your own, like absent any kind of supplemental sent on you, or do you kind of wait for that supplemental and keep a running list of things you're going to have to update?
Okay, so I have two answers. My like perfect me, yes. As soon as I get them, I want to update them.
Yeah.
In a realistic world, it's so hard to, because let's say I get new records, but I know I have an order for like 3 more facilities. I'm like, oh, well, I'll just update them once I have all those records.
Send it once instead of
But then, you know, life happens, you've got other depositions. And so I make a reminder, and I've only started doing this recently. I should have done it earlier, but a few months before my trial date, I know my discovery cutoff. So I'd go, okay, discovery cutoff's X date. I go a few months before then and I make a calendar reminder in my Outlook. And it's just for myself. I don't have my paralegal do it, but I go, you need to go through all the medical records and need to figure out if we're missing anything. And we need to update everything, update our responses. Yeah. So maybe the defense will send me a supplemental request for interrogatories, and great, I already have everything. But I try to at least 2 months before the discovery cutoff have everything over, because it creeps up on you. It really does. Yeah. All of a sudden your discovery cutoff's a month away and you're like, oh my gosh, I need to order these records, and they don't get here in 30 days. I'm screwed.
Yeah, no, absolutely. And I think that's smart. And kind of like, how do you keep track of it? So if you know, like, okay, I'm waiting on this, this, and this, do you kind of just like, are you able to have that in the bank of your mind and just like, okay, like I'll come back to this? Do you take handwritten notes? Do you have like a running case list note?
I do 2 things. I use OneNote. I don't know if it's the best software, but that's what I use. I used it in law school and it worked. So I have a list of all my cases, and then I have like important deadlines. And in every single case, I have, okay, trial date, discovery cutoff, and then 60 days before discovery cutoff. And the reason I do 60 days is because, so let's say discovery cutoff is May 1st. So that's when it closes. So I need to make sure I can serve my requests for more supplemental responses 30 days before them, and then make sure I'm on top of everything 60 days before so that I have enough time. But I think that's just like more of like a personal thing. I'm sure other people do it differently, but when you're starting off, you need to know your deadlines. Do not rely on your calendar. The calendar reminders are great, but sometimes, you know, you're in the middle of something and you dismiss that reminder and you forget about it.
Totally.
So I have my OneNote, and then I have my planner, my hard copy planner. I love like hard copy things. Same. And then I have that little calendar that's on my desk that I think you sent me the link for. So I have 3 different sources, and I'm very big on like, I need to know my trial dates and my discovery cutoff dates, and then give myself that window. I know I need 60 days. Maybe some people need a little bit more. So like, do what works for you, but know your dates.
Yes.
Do not let those dates slip.
I think that's genius. And I think it kind of goes to just like everything is a trial and error, right? Yes. So it's like maybe you try 30 days and it's like, okay, no, this is way too crunch time, fast, like rushing. So then you try 60 days. Like it's not being married to one thing that you start. Yeah. Like it's constantly giving yourself grace and patience to just kind of like work with it and find what works for you.
Yeah. And I think another practice tip is don't be, like we were mentioning earlier, don't be reactive. Yeah. So being reactive is waiting for the defense attorney to serve you with supplemental requests for interrogatories. Sure, that might happen. But what if it doesn't? And now you forgot to order certain records that you needed. Like, for example, let's say there was a surgery in your case and you don't have the bill. You need that bill for sure for your exhibits. So don't be reactive. Constantly look at your file and look, did the client get additional treatment? Why is this, why is this folder empty with no records? Like we need to make sure we're on top of it. The imaging. Sometimes we have the reports, which is great. You need updated reports, but you actually need the films. And I know that when I first moved over to plaintiff's side, that was something that I wasn't used to. So it would slip my mind and we would get closer to trial and they'd be like, where are the films? I'm like, oh my gosh, we have to order the films? So it also touches on, you don't want to have your staff constantly getting rush requests. Right. And I know I would hate that personally. So I constantly make sure I have reminders like if the client saw this MRI facility, maybe give them like 30 days and then request the film. So it's not on a rush basis, but
yeah. No, I think that's a good way, like kind of having a checklist for yourself where it's like for each case, like, okay, I know that this client just told me they're getting another opinion. They're getting a second opinion. So like I write that date down in my calendar and then I have a reminder for like a week after that to order the records from that appointment. So it's also kind of constantly being in communication and knowing where they're at in their treatment. Yes. Too, so that you can know to do that so you don't have to do it last minute.
Yes, that's huge. I think some clients are better about it and they'll, they'll just say, look, I went on my own and I've been trying out this new like acupuncture, and you're like, great, I need to know that so I can request the records. Yes. Please send the address.
Yes, exactly. And so that kind of goes into something that we've touched a little bit about like different sessions for discovery and asking your client those questions to go through them. Do you have kind of a practice that you usually use where do you kind of break it up and make them more digestible? Do you kind of sit down and be like, I already have the answers to a lot of these because we've already had these conversations. And so they're kind of like, you can hit it out in one call.
It depends on the sophistication. Sophistication, is that a word?
I think so. Sounds good.
I think it depends on like how sophisticated your client is. Some clients, they are just like so organized and like, boom, I saw this doctor. Boom, this doctor said this. Some clients are just like, I saw a doctor. I don't even know what it was for, but he said X, Y, and Z. And so it's like, okay, let me figure out what my client needs. And if this client can knock it out in one session, and maybe they only have like a small set of questions to go through, we can do it in one session. Personally, I don't think that happens in the majority of cases. I've always had like at least 2 to 3 calls. Yeah. And sometimes a Zoom because they have to see the document and like process that. But making it easy for the client, because we cannot, I mean, we probably could go through 2,000 questions in one session, but we would both be exhausted.
Totally.
And I also don't want them to be fatigued when we're answering these questions. So I think for the most part, one session for like an initial like basic information. The second session, let's go through all your medical records and let's go one by one. And it's also an opportunity for depo prep. Because as you're going through them, it's like, okay, yeah, I remember I went to this chiropractor first, then maybe I went over here. My PCP told me this. So really breaking it down for them. And then maybe the third session's like, all right, we have everything done. We just want to make sure if there's anything else we need to clarify, or maybe something isn't as concise as we want it to be. Let's go through that.
Yeah.
But it's just, you cannot rush discovery. You really have to, like, as soon as I get that incoming discovery, I book a meeting with my client. Perfect. When can you meet? Let's book out another one as well.
Yeah. No, I think that's genius, because you don't want to be, like at the last minute where it's like, oh, I need you to send me the photos that you just realized were on your iCloud that you didn't send me yet, or things where it's like, I don't want the client to only have 2 days to send me those documents or those pictures. And I think that kind of goes into like, I'll have an expectation call with my client. I'll be like, hey, like, what are your work hours? Like, do you have X amount of time to give me to go over this discovery call? I'll try and kind of preempt, like, I have a lot of information that I can kind of fill in before going over it with you. Or it'll be like, hey, like, I have a lot of questions. Like, it might be information overload. It might exhaust you. Do you want to break this up? Like, how much time can you devote to this? Do you have an hour, or do you want to do multiple 20-minute sessions? Because then I can kind of go through the discovery first and group them into themes where it's like, okay, I'm going to ask. I do that a lot. I'll ask like all of the injury questions. I'll ask all of the background questions. I kind of group them for each session so that it's not like chaotic every time where it's like, oh, did we go over these? So it's not always going in order. Maybe I just have like a running list of like the themes of the types of questions that are being asked so that I can then kind of go in. For sure. I think for me personally, I have a law clerk that assists me with the initial responses, right? But you can't always 100% rely on someone else because for instance, I had a Prop 213 issue come up. There's no way my law clerk would have caught that. You know, she's just looking at the police report, going off of the medical records and doing the best she can. And so I'm going through and it's an initial meeting with the client, and then this Prop 213 issue comes up, which we can do a whole segment on that. But essentially it's when your client doesn't have insurance when they get in a collision. And so the way that issue impacted our discovery, I had to go through and update almost like 50% of the discovery questions. Right. So if you are, it's just a practice tip. If you are having someone assist you, whether that be a law clerk, a paralegal, another associate, you need to review everything and make sure that when you're actually going through this with your client, that you're not skipping questions. Because I think it's very easy to be like, oh yeah, we got that from the police report. Verify the police report. Sometimes not agree more.
The police report's wrong. Yeah. I've had that happen a lot. So.
Yeah, where they put the wrong insurance or they put the wrong policy number or things where it's like you should definitely be checking it. So you might have this like cursory understanding, but there might be more to the picture. And I think we do a disservice to our client the second that we just like assume something without giving them the opportunity to speak on it.
And I think sometimes attorneys get a little nervous. They're like, oh, I don't, the client was already asked that during the intake process. Like, I don't want to re-ask that. And it's kind of what you were saying earlier. It's like, I know that you already answered these questions. I'm verifying that there's, if there's anything that changed or maybe it slipped your mind, is this still accurate? Because you're signing under penalty of perjury. So we just want to make sure any changes, anything that's, not accurate on these statements. So I think that's always just double check, triple check.
Yeah.
Be consistent.
Be consistent. That is a very
That is the theme of this episode.
We'll get it on a pillow. I think we're about to wrap it up, but I think that discovery is something that we can literally talk about like every single time because there are so many different types of strategies and ways to explain and differentiate and kind of go through with your client and asking the questions that have been asked probably from the inception, but things where it's like the more that you kind of think about it and maybe you not necessarily plant a seed, but you kind of get them to start thinking about something that they might not have even like thought about in like years. So giving them the time to kind of process that and then coming back to it, I think is always really important too.
We could literally do a month of just discovery.
Absolutely.
There's so much to cover, but I think maybe we'll do like one session on just like the 12 series and give examples, or I don't know. We'll see.
I know. I'm like thinking about all of the series and all of the things.
Yeah, so much to go over.
Yeah. And there's time, and we will.
Yes, we will.
So thank you very much for tuning in to this week's Ladies in Law. Again, I'm Michaela, and this is
Allison.
Thank you, and stay tuned for the next one.
Thanks, guys.